about the USA? Do you know about the government? Can you tell me about the Constitution? Hey, learn about the USA. In 1787, I'm told our founding fathers did agree to write a list of principles for keeping people free. The USA was just starting out, a whole brand new country, and so our people spelled it out, the things that we should be. And they put those principles down on paper and called it the Constitution. And it's been helping us run our country ever since then. The first part of the Constitution is called the Preamble and tells what those founding fathers set out to do. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. In 1787, I'm told our founding fathers all sat down and wrote a list of principles that's known the world around. The USA was just starting out, a whole brand new country, and so our people spelled it out. They wanted a land of liberty, and the preamble goes like this. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America, for the United States of America.
We the people of the United States, in order to form a more perfect union. This is the preamble to the Constitution of the United States of America. This document, written more than 200 years ago, forms the foundation for the United States government. In fact, it forms the United States government. It exists because of the Constitution. Unlike other countries such as Great Britain, the United States has a constitution, a formal document forming its government, a formal document which also sets forth many of the values that the United States now holds so dear. While the document speaks of forming a more perfect union, it was indeed a flawed document. Even with all its flaws and mistakes, which we will discuss later on, the Constitution is the supreme law of the land. No law at the federal level, no law at the state level, not even a state constitution can contain a provision which violates the Constitution of the United States. The Supreme Court cannot modify this Constitution. The Congress cannot on its own modify this Constitution, nor the President. The Constitution can only be modified in accordance with the provisions of the Constitution. It is indeed the supreme law of the land. The Constitution of the United States is a relatively short document, and in fact, its genius is sometimes found is in the shortness of the document, how it leaves things to be worked out. The Constitution is a living and breathing document. Therefore, it allows for the nation to grow and change by maintaining the same Constitution. That is why it has lasted for more than the 230 years of its existence. But for all of its brilliance, it also had its flaws. The Constitution was written by flawed men. These flawed men brought those same flaws, those same isms and prejudice to the document, and therefore it excluded, when written, most Americans. It is an example of racism, sexism, ageism, and virtually any other ism that we now recognize. And therefore the Constitution has, over its many years, been modified and interpreted with various other institutions created to make a document which could not foresee the nation that we have now, with an African American president and African Americans educated and women. That document did not envision that. It has subsequently grown to have that kind of America. Nations act like people, and as a result of nations acting like people, and they act like people for one good reason, and that is because they're made up of people. And so nations act like people. They are motivated by the same things that individuals are motivated, primarily by our fears and by our hopes. This Constitution was motivated by the fears and the hopes of those who drafted it. Let me give you an example of how those fears and hopes are reflected in this Constitution. The nation just finished a war with Great Britain, a war separating from a nation that was ruled by a king that was all-powerful. In fact, the notion that the king can do no wrong came from the British monarchy. This nation was involved in that war, and therefore there was a fear, now that they were forming their new nation, that there would be the concentration of power into one man or one person's hand. They did not want to have that concentration of power, and therefore our Constitution reflects that fear in the checks and balances and other check systems that it puts in place to ensure that no one person, no one institution is all powerful in the American governmental scheme. The hope of the drafters of the Constitution was that power could be shared amongst co-equal branches or amongst different institutions created within the Constitution. Therefore, while power is not concentrated, it is shared. There are some checks and balances amongst those who are sharing that power, and you protect it against that concentration of power that once existed with the king. The Constitution also reflects the fear of popular control. This sounds funny, the notion of a republic being something fearful, but at the time that the American Constitution was drafted, there was no other democracy that had popular elections. In fact, there was no other democracy. So this was a great experiment, letting individuals choose their own leaders. The world was by and large a world run by monarchies at that time. So there was a real fear among the drafters of the Constitution on the issue of popular control. I mean, as the notion of a democracy was a new notion, the concept of representative government was a new notion, and this was a grand experiment. You had a grand experiment taking place amongst a people who had not yet come together as a unified nation, people who were from many places. You had this experiment going on among people who were did not think of themselves initially as Americans, but members of individual states. And now you are trying to give this relatively uneducated group of men, and that's who it was, men. But amongst this relatively uneducated group of men, you are trying to now give them some right to select who their leaders were. And that was an untested theory that they were about to embark on. They had fought a war, and now they were about to embark upon a grand experiment. But just as they had fear, they also had hope for a just society. Now, that their notion of justice is quite different from our notion of justice now, because that notion of justice was justice amongst those white men who owned land and who had some level of privilege. But it did lay the foundation for the nation we now so proudly wave the flag of. The United States Constitution was bold in many respects, and one of those respects was some of the values that it indeed reflects. One of the first values that it reflects is the notion of popular sovereignty, the concept that now seems to be just normal, part of a regular human right, but at that point was a novel concept that people can elect their own leaders. People can select the people who would lead them. That was a rare, a novel concept at that point, and was not happening in other places. Again, it was a world dominated by kings and those who assumed leadership by divine right. The U.S. Constitution took a different stance. It said the power of government is derived from those who are governed by the government. Therefore, it took the notion, as Lincoln put it, that government of the people, for the people, and by the people was indeed what the United States government was going to be about. The government had to meet the needs of the people in order for government to have a legitimate purpose. And we go back to Maslow. Government had to meet those needs, that hierarchy of needs, in order for government to be legitimate. And in fact, that is true today. For government to or any government to be a legitimate government, it has to seek to meet the needs of its people, and those needs are pretty well defined by Maslow's hierarchy. Now, while some would want to get maudlin and overdramatic about this Constitution allowing people to elect its own leaders, let us still remember that in this particular instance, at this point in the Constitution, in the drafting of the Constitution, the people were defined as white males with land, and therefore it was allowing a pretty exclusive group of men in the all boys club, the all white boys club for the most part, to participate in full opportunity of the democracy. Even though white women had some protections, they didn't get the full opportunity of democracy. And even after the various amendments allowed for minorities and women to vote, voting rights acts and other things had to come into place for the full protection to be given. The U.S. Constitution also embodies the notion of limited government. Now, when I say limited government, I do not mean the limited government of the libertarians or the limited government even that the Republicans or Democratic Party wants to talk about. When I talk about limited government, I mean limited government in the sense of limiting the powers of government over the lives of people and limiting the powers of government over the functioning of the nation. Uh, this this Constitution did not want to create anything like a king. It wanted to safeguard against tyrants, and therefore it was not creating a government that had all power and that all power rested in government's hand. In fact, in this notion, the power belonged to the people, all power rested in the hands of the people and was given to government by the people. And so, therefore, the government had limited powers under the concepts that this Constitution was written under. In fact, let me give you an example of some specific provisions. Government is limited and limits itself in this Constitution in many ways. No bills of attainder. Therefore, you cannot pass a law which is so narrowly focused that it is directed at a particular person, either giving that person something or taking something away from that particular person. You can pass laws that impact groups of people, but not laws that focus narrowly on one individual or very few numbers of individuals. Our Constitution prohibited ex post facto laws, which meant that you cannot go in and create a law to make illegal or improper some action that has already occurred and then impose the punishment upon a person for something they did prior to the law being enacted, prior to, in essence, they did it while the law did not prohibit it, and therefore you cannot make it illegal. You cannot go back and make something illegal that was legal or not prohibited when it was done the first time. Those are all limits on government's powers, on how government can act. What they were trying to do is prevent, in essence, a king, in essence, someone coming in and assuming more power than is written in the Constitution. In fact, they went back in amendment and said any power that we did not specifically reserve to the federal government goes back to the states, because remember, this Constitution forms the United States. It speaks to the formation of states as members of the Union and people as citizens of states, who then are subsequently citizens of the United States. But basically, its desire is to take from a loosely gathered group of states and create a union, one nation out of those states, with the individual citizens as citizens of the states and therefore citizens of the United States. The Constitution, again, in its effort to not have to have limited power and to not create a monarchy again, had a provision in it unique for its time that allowed for impeachment, the removal of leaders who had overstepped their power, committed high crimes or misdemeanors. That, again, was unique in the sense that the king could do no wrong, and therefore the king had no way of removing the king short of death. Now they have brought in an elected leader, and even that elected leader can be removed from office should that elected leader engage in conduct in violation of the provisions of the Constitution. In essence, an elected leader who's engaged in high crimes or misdemeanors. From the start of the United States, there's always been a question as to how power would be divided between the state and the national or central government. That concept of federalism is embodied in the Constitution of the United States. The concept that power is shared between the national government and the state government, and how that power is shared. Some of the major divisions in this country have been focused around the issues of states' rights. States' rights is a common cry, and was a common cry from the beginning. While the national government has the supremacy clause in the Constitution, which protects it, that supremacy clause in terms of the national government over the state government has never been terribly clear, because there are provisions. There's a provision in the U.S. Constitution that says all power not specifically reserved to the federal government is reserved to the state government. The concept that power of the federal government is derived from the states. It was ceded by the states to create the federal government. All of those impact the sharing of power between the federal government and the state government. As I said, states' rights was a common cry throughout our history. If we think about it, the issue of slavery turned upon states' rights. Now, it was the states' rights to determine for themselves whether they should own and be able to sell and trade in human beings, but it was a states' right. States were saying we should have the right to make that determination. It should not be up to the federal government. Even though there is a constitutional provision which prohibits the importation of slaves after a certain date in our history. The states were arguing they have the states' rights to make that determination. The issue of integration or civil rights was states arguing that states should be able to regulate, treat its citizens within the borders of that state, and therefore it was the state's rights to determine how it would provide education, whether separate but equal, was something that a state could determine what it could do. The issue of abortion, again, it can center around a state's rights issue. Some arguing that it is the state's right to determine how it would the rights of the unborn versus letting the federal government, since the federal Constitution has nothing specific about it. The moral questions of our day about marriage, same-sex marriages, those issues, those moral questions of our day that are specifically mentioned as rights within the federal Constitution, the argument is they're states' rights, and the state has to determine. So we still are making around the issue of states' rights and how power is divided between the state and federal government. The issue of federalism has again been struggled with in the history of the United States, but through the interpretation of the Constitution and through various laws, federalism has worked itself out, and therefore powers seem to fall into three categories. Powers that are federal government only, powers that are state government only, and powers that are shared. Let me talk about each. Federal government powers are those that require some uniform national scheme. So the federal government powers only with things like immigration and naturalization. You don't need to have each state determining what it takes for someone to become a citizen of the United States. Another example is bankruptcy or coinage of money. You certainly don't want to have bankruptcy laws, particularly for multi-state organizations, being different in one state or the other. An organization that functions in many states must have one uniform set of bankruptcy laws to either deal with as it's filing bankruptcy, or to collect its debt as it's working with someone who's filed bankruptcy. Coinage and money, you certainly don't want to have different money from one state to another. The United States once in its history did have that, and that certainly makes commerce very difficult, since there are exchange rates and other things that have to be worked out just to deal with money from one state or another. Same thing for weights and measures. They need to be a uniform set of things. Treaties, you can't have foreign affairs being administered by 50 different states. You have to have a uniform set of foreign affairs, and the president has to be in charge of those foreign issues. On the other hand, states have the right to deal with their education. The federal Constitution has no provision which addresses the issue of education. There's no right to an education growing out of the federal Constitution. That is a state issue only. It is a right that is reserved by the states, and education can be found in most state constitutions, and that is an issue that the states would regulate and control. Whereas the federal government has the rights over navigable waters, non-navigable waters, that is, waters that aren't big enough to get major ships and vessels through, run interstate commerce through, are state. That means within the state borders, they're going to regulate those waters and streams that are non-navigable. But certainly those big navigable waters, the ones that would be a result of interstate commerce, meaning moving goods from one state to another, those kinds of waters are going to be governed by the federal government, because you can't have one state regulating these navigable waters and damming them up and blocking commerce through its state, while another state's trying to get navigable waters and get commerce in its state. You can't have commerce dependent upon each of 50 states. You need a uniform scheme, whereas non-navigable waters certainly should be, they're within a state, they shouldn't be controlled by a state. Just as commerce within that state should be controlled by that state. You can have 50 different schemes because you have commerce in 50 different states. But there are some powers that are shared. For example, labor laws and trade laws, mining laws, all those are shared. Both the state and the federal government will have provisions which govern them. Roads and navigable waters within the border of a state, the state will have some ability to regulate them, but not certainly the ability to shut down navigation. They're going to be subject to the rules of the federal with regards to that. The allocation of resources regarding health, that's generally a shared kind of allocation, because both the state and the federal have an interest in that area. So what we have in our Constitution is federalism, where the state and federal government sort of have a understanding based on the Constitution, laws, and president as to where the power lies between them and among them. So in some instances, it's only the federal government. Only the federal government can declare war. But where there's a need for a uniform scheme, it's only in the federal power. Where there can be a hodgepodge of scheme and you allow the state to make that determination, it is a state determination. And in some instances, it is shared. Generally, policy set at the federal level, implementation with some policy flexibility at the state and local level. The fear of the concentration of power in one person or one institution's hands can be seen throughout the Constitution. And the concept of separation of power, which is found throughout the Constitution, is a result of that fear. while it separates the power, creating a legislative branch, an executive branch, and a judicial branch, which constitute the three co-equal branches of government. People often think the executive branch is higher than all the rest. No, the president is the head of the executive branch. You have the Speaker of the House and the President pro tem of the Senate, the head of another branch, and you have the Chief Justice of the Supreme Court, the head of the other branch. Each branch has checks and balances over the other branch. The legislative branch makes the laws, the executive branch carries out the laws, and the judicial branch interprets the laws. Now, each one of them, the executive branch, can veto the laws of the legislative branch. That's their check. The legislative branch has the right to override that veto, and the judicial branch has the right to interpret the laws in such a way, in a manner consistent with what they think to be the Constitution and the legislative intent of the laws. And the legislative branch has the right to rewrite the laws that they think the judicial branch has interpreted improperly. And so there are checks and balances that each branch has over the other. These checks and balances work good in disseminating the power amongst the branches, but it also means that there are certain inefficiencies as one branch can do away with, in many instances, the work and effort of another branch by either vetoing it or interpreting it in a way other than the way it was intended. And while certainly the abuse of that power, particularly the judicial branch, can result in impeachment if it was an intentional misuse. The likelihood is an intentional misuse just doesn't come. It can't be proven, and very few judges have been impeached for some intentional misuse unless you find graft or corruption or some criminal act having occurred. So some of these checks and balances aren't quite equal. But what I want you to understand from this particular review of the Constitution at this portion is that there are some concepts that run throughout the Constitution, and they are born out of our fears and our hopes. But some of those concepts are the issue of popular sovereignty, people voting for their own elected leaders, limited government, meaning government not being unbridled, there being checks and balances that prevent government from going unfettered. Federalism, which divides the power amongst the federal government, the state, and shared power. The concept of separation of powers, which divides power of the federal government between three co-equal branches of government. All of these are concepts that run throughout the Constitution that we'll study further.